Hello, everybody, and welcome to the next edition of the Employment Insights podcast. My name is Rebecca Kearney, and I'm a partner in the employment team based in Liverpool. I'm joined today by my colleague Mark Landon, who is a partner based in our London office. Hello, Mark, and thank you for joining us today.
Hi, Rebecca. It's a pleasure.
So today we're going to be discussing home working, so employees' rights when it comes to home working, any future potential changes, other legal considerations for employers to consider, and also the practical challenges in managing home workers. So to kick off then, Mark, why do you think there's been a growth in atypical working and specifically home working in recent years?
I think there are a number of factors. I think there's been an increase in partners sharing family responsibilities. I think longevity. I think actually people are often having to work longer to provide, for funds in retirement. And of course, they may not want to work 5 days a week in an office, whatever it happens to be. And I think also there's often an increasing need to provide care for elderly relatives, which means that people might need a more atypical working pattern in order to have more time to do that. I think the
Yeah.
increased cost in higher education means that we've got larger numbers of students who are available and need part-time and casual work. I think also the increased financial pressure on employers because a flexible workforce gives you a greater ability to meet fluctuating demands without having a sort of full-time payroll. And I think also one mustn't forget that these days, many employers are able to reduce the amount of office space or workspace they provide on the basis that people will be working from home at least part of the time. And that can have a significant saving in terms of rent. And I suppose the other thing, of course, is unforeseen events like the COVID-19 pandemic, which has accelerated technological developments, which in turn facilitate our ability to work remotely. So I think it's a combination of things. Of course, we are seeing, I think, some employers wanting people to come back to the office more. I think it is a pendulum that swings, but I think those factors will remain in play going forward.
Yeah, absolutely. The COVID-19 pandemic was a big one, wasn't it, in driving that atypical and certainly the home working forwards.
Yeah, I
So
mean, I
is
think
is
it was happening already, but I think it certainly accelerated it. And I think what it did do is it provided some hard data as to people's productivity if they were working from home. I
yes,
think a lot
yeah.
of employers assume that people often wouldn't be able to work productively. And I think, that was the hard test, if you like.
Yes, absolutely, absolutely. So is there actually a legal definition of what constitutes a home worker?
No, I don't think there is. And of course, you might have somebody who works at home full time, although I think that's quite rare. The majority of people, I think, will work from home on a part-time basis. You might be, an agile or hybrid worker, which is a term that's often used for that. It might be that actually you're a very mobile worker and your home is your administrative base. It just makes more sense to set off from home and return home each day than to go into a workplace. So, I think a home worker is just an atypical worker, and there are many shades of grey. And of course, you may be atypical in other ways. I mean, you might be a home worker who works part-time or under a fixed-term contract. So it's not as if there's only one category of atypical worker who might apply to an individual.
Yeah, no, absolutely. And so do employees have a legal right to work from home, either part-time or full-time?
Well, not in statute. It may be that under your employment contract, it is a term of your contract that you can work from home full or part-time. And I think certainly one sees these days when people are being recruited for a role, one of the questions they'll often ask is actually, what are the arrangements around home working and agile working? But I think when it comes to the actual law, I suppose the closest thing is that there is a legal right to request flexible working, which request might involve home working, and the employer has to consider that seriously, but it's not actually a right to work flexibly. And I guess probably discrimination law is the thing that impacts as well, in that actually in certain circumstances, an unreasonable refusal to permit home working, either full or part-time, might give rise to a discrimination claim. And, we can have a chat about that in a minute. I think, of course, what you have to bear in mind as an employer, that accommodating home working requests can have very positive benefits. It can certainly facilitate recruitment and retention of staff by meeting personal needs. I think it can improve people's morale and often quality of service and strengthen the employer's reputation. And remember, we have an aging workforce in the UK, and all employers are in increasing competition for the talent that's out there. But of course, home working requests have to be balanced against the commercial and operational needs of the employer. And I think what is really important, and we can come back to this later on when we talk about common challenges, is to make sure you adopt consistent criteria when deciding to whom you might grant home working. Because I think what is really important is to avoid a sense of favoritism and so on and so forth. And also, of course, to make sure that if you do grant home working, it doesn't lead to performance concerns, because your criteria ensure that you balance the individual's desire for home working against the needs of the organisation.
Yeah, absolutely. So if an individual doesn't have a contractual right to work from home, whether that's part or full time, or can we chat through, I suppose, the legal rights that are commonly associated with home working and what people should be considering?
Sure. I mean, I think there are probably sort of three or four. And there's the right to request flexible working. And I'll briefly summarize what that is. I think there's the impact of equality law. There are health and safety concerns as well, because the duty to provide a safe place of work would extend to the home if you're formally permitting somebody to work from home. And then I think there are cyber security and data protection issues, because almost by definition, if an employer's network is extending to the home, well, the kit that somebody uses at home, the antiviral software, etc., means that you've got to ensure that you are guarding against cyber and data protection issues. So I suppose if we look at those in turn, starting with the statutory right to request flexible working, well, of course, it's a day one right, and you can make a request for any reason. It used to be limited to caring needs, but it's no longer. And you can now make 2 formal requests a year in a 12-month period. And of course, it's one of those slightly odd things that when you look at the law, it says that a request for a temporary or permanent change can include one or more of the following: a change to hours of work, the times when you work, or your place of work. And it can be a combination of those. And so essentially, the right to request flexible working means you could literally ask for any sort of pattern of work under the legislative regime. Now, you've got to put in a written request. You should specify that it is a formal statutory request. And certainly the ACAS Code of Practice says that it's important to provide as much information as possible about what you're seeking by way of a change, the circumstances that have led to it. And also, I think, you should specify if you're making the request in relation to some right under equality legislation. So if, for example, it was a disability-related adjustment that you were seeking. And all of that, of course, is important because, as I'll mention in a moment, under the new Employment Rights Bill working its way through Parliament, there is going to be quite an important change made to this right to request flexible working. Now, what the law says is when you receive as an employer a request for flexible working, you've got to deal with it in a reasonable manner. If you're not going to say yes, you've got to consult with the employee before refusing the request. And I think a key part of the consultation is to see whether there is some compromise you might come to. You've got to notify the employee of the decision, including any appeal outcome, within a 2-month period. And importantly, if you're going to refuse the request, then there are 1 or more of 8 prescribed grounds upon which you can refuse. So the burden of additional costs, the detrimental effect on meeting customer demand, an inability to reorganize work amongst your existing staff, an inability to recruit additional staff, detrimental impact on quality or detrimental impact on performance. There isn't enough work during the period when the employee wants to work, or else you've got planned structural changes coming in and it's just bad timing. It's just the wrong time to be considering a request. Now, I think the change that we're going to see that's very material under the Employment Rights Bill is currently if an employer says no and cites 1 or more of those 8 reasons, there's no actual statutory requirement to explain exactly how that reason applies and what considerations you've taken into account before deciding to reject the request. ACAS says you would do well to provide all of that information, but there's no actual obligation to do so. However, as from 2027, under the Employment Rights Bill, an employer will only be able to refuse a request for flexible working if 2 things apply. The first is that the employer considers that the application should be refused on 1 or more of those 8 existing prescribed grounds. But secondly, it must be reasonable for the employer to refuse the application on 1 or more of those grounds. And if you do refuse the application, when notifying the employee of the decision, you've not only got to state the ground or grounds for refusing the application, but give a full explanation as to why you think it was reasonable to refuse that application. What this is going to mean is I think employment tribunals have now got a much greater, will have a much greater ability to scrutinise the employer's decision-making than it currently has. I think a lot of critics of the current right to request flexible working would say it's a bit toothless because essentially employment tribunals don't look behind the reason. Whereas I think as from 2027, if actually it's down to an employment tribunal to judge whether it was reasonable for the employer to refuse the request on 1 or more of those 8 grounds, well, it will be able to scrutinise what your thinking was and what your reasons were. So I think that's the first thing, the right to request flexible working. And I think, clearly an employer that just didn't give proper consideration to a request for home working might find that they came a cropper. But if you then look perhaps at equality law, I think in practice that tends to be something which employers worry about more. And I suppose the sort of most common equality law issues are sex discrimination and disability discrimination. So if you're looking at sex discrimination, the kind of classic is where somebody is requesting home working because of childcare reasons. Now, the courts take what's called judicial notice of the fact that women are the primary child carers in the UK. We may all think now, well, society is changing and that's much more shared, but at the moment, you don't have to prove to a court that women are the primary child carers. They recognise that that is the fact. And what that means that if a female employee requests full or part-time home working for childcare reasons, and this is rejected by the employer, then she might bring a claim for indirect sex discrimination on the basis that women are more likely to be sort of inconvenienced by such a refusal than men, because women are more likely to be the primary child carers. And of course, what that would happen is the employment tribunal would have to assess whether the employer was justified in rejecting the request for full or part-time home working. And of course, things are never that simple, because since January 2024, if a dad wanted home working full or part-time for childcare reasons, and could show that actually he was put at substantially the same disadvantage as a female comparator by an employer's rejection of a request for flexible working, well, he too now can bring an indirect sex discrimination claim. And also, the spectre of direct discrimination arises because if an employer granted a home working request for childcare reasons to a female employee on the basis that she was more likely to be the primary childcarer, but didn't grant a similar request to a male employee, well, you could see that if the reason was that he was male and she was female, you're going to end up with a direct sex discrimination claim against the employer. So, essentially, I think the practical issue is these days that as an employer, if either a male or female member of staff makes a request for home working full or part-time for childcare reasons, you've got to have regard to indirect sex discrimination. And then, of course, disability discrimination is one of the really key equality issues, because if an employer receives a new request for home working or faces resistance from an existing home worker who doesn't want to return to the office on a full or part-time basis, and in either case, the employee maintains that home working is, in part at least, necessary due to an underlying disability, then any refusal to accommodate the employee's wishes could result in an employment tribunal claim based upon one or more of indirect disability discrimination, discrimination arising from disability, and/or an alleged failure by the employer to make a reasonable adjustment. And of course, one often describes these as the sort of holy trinity of disability protection, because with regard to an allegation of both indirect disability discrimination and discrimination arising from disability, there is a justification defence. But a justification defence is typically going to stand or fall on whether the employer actually fulfilled its duty to make reasonable adjustments. And you can see the argument would be that if an employer has a policy, for example, of only permitting home working up to 2 days a week, requiring people to come back to the office for 4 days a week or whatever, the challenge would be that actually if a disabled person was put at a substantial disadvantage by that policy, remembering, of course, that substantial in this case means simply more than a minor or trivial disadvantage, then the argument would be that the employer should, by way of a reasonable disability-related adjustment, allow more home working. Now, you've got to, I think, reasonably balance that, because I don't think anyone could normally reasonably say I must be allowed to work from home fully and never come into the office. I think most courts would recognize that there's an obvious benefit in people attending at least on a periodic basis, but it's going to be very fact specific. And I think the other thing, of course, is this: if I do allow someone to work from home for a disability-related reason, and if in fact I implement various disability-related workplace adjustments in the office, do I have to replicate those adjustments in their home, or at least give them a means of, carrying any bits of equipment or adjustments between office and home? Because, there is also the issue that if I am requiring someone with an underlying disability to commute 2 days a week, well, actually, I've got to make sure they can do so safely and effectively. So I think from a practical perspective, disability discrimination, and bear in mind, I think one of the benefits of COVID-19, and we talked about this a bit earlier, is there is hard data now to show whether people can be productive from home. And I
Yeah.
think actually home working now does provide a reasonable adjustment in itself, which probably a lot of employers pre-COVID wouldn't have seriously considered. And
Yeah.
so I think there is actually a greater scope. But aside from sex and disability, I think you've got to bear in mind, there are those 9 protected characteristics under equality law. And so you might get a request for home working linked to maternity. I mean, say, for example, during the latter stages of my pregnancy, I was struggling to commute full time and I wanted some home working. Might be age, simply age discrimination. I need to work longer, but actually I'm finding commuting, full time very tiring and I want to have a good balance. It might be religion or belief. Say I want to work from home during a period of fasting when commuting might be more tiring. So, I think what the employer needs to do is to be quite open-minded about the fact that under equality law, there might be one or more reasons why someone is seeking home working on a full or part-time basis. And I think what this does mean is that any internal policy and procedure covering the right to request should ensure that employers are encouraged to explain very fully the reason or reasons behind the request for home working. And certainly managers should never reject a request for full or part-time home working without sitting down and properly exploring all the underlying reasons. And if there is
Yeah.
anything that suggests there might be an equality-related link, well, you're going to have to properly explore that and show you've explored it if you're going to be running a sort of justification argument for saying no. So I think that's equality. I guess the other things to bear in mind, if you're looking at the sort of legal rights associated with home working, are health and safety and cyber and data security. So health and safety law comprises legislation, the Health and Safety at Work Act 1974, and supplemented by various common law duties and codes of practice and other guidance. And essentially, under Section 2 of the Act, employers must, so far as is reasonably practicable, provide and maintain safe places of work, safe systems of work, and adequate facilities and arrangements for welfare at work. Now, if I'm formally allowing you to work from home part-time, I've got to make sure that your workstation at home is fit and proper for you. If I am allowing you to carry equipment to and from the office, I've got to make sure that you can do so safely. These are all things that I need to bear in mind. And I think with things like workstations at home, an awful lot of employers will provide sort of online videos to enable people to sort of self-assess their workstations. But I think it is very important to have an appropriate policy that governs home and agile working and also explains what the health and safety obligations are. Remembering also, of course, that employees are under a duty to look out for their own health and safety as well. But, that is something that shouldn't be overlooked. And I think there is a difference these days. Pre-COVID, working from home on the odd day, fine. But actually, and you might sit at the kitchen table on a pretty uncomfortable chair, but it was a pretty irregular thing. But as soon as it becomes a formal part of the working arrangement, really the employer is under these health and safety obligations. I think the other thing with health and safety is monitoring the ongoing well-being of home workers, because the experience of many people during the COVID lockdown was that you could see the potential detrimental consequences for mental health, whether or not someone lives alone. And I think that a responsible employer needs to implement practical measures to monitor people's well-being, taking into account the increased remote nature of many people's working lives. I think ensuring a reasonable amount of office attendance and a structured approach to management, including regular face-to-face feedback sessions, enables one to just actually check that people are okay. Because I think
Yeah.
even with a Zoom or Teams call, if I say to somebody, how are you? And you go, oh, I'm fine, it's quite hard to pick up on those visual signals that tell me you're clearly not fine, as compared to sitting across a desk or a cup of coffee talking to you in person.
Yeah. Yeah.
And then I think the final two things, just, I'm pretty sure I've gone on long enough, is cyber and data security. And I think, employers must ensure that appropriate levels of cyber security are applied and adhered to by those working from home. And so you might say, for example, that you can't use your own home PC to access work. You would have to use a laptop provided by work with all the sort of suitable antivirus things applied to it. And obviously data protection. I mean, the classic one is don't leave the laptop on the train. Um, Also, I think you've got to think very carefully. Do you allow staff to take documents out the office? Most employers won't now. But you've got to make sure you've got guidelines and measures in place to protect against that, because inevitably, I think if you are allowing people to work from home, you are potentially increasing the risk with regard to cyber and data security.
Yeah, so there's an absolute load of things for both employers and employees to consider then by the sounds of it, certainly on the legal front. I mean, what about the practical side? Are there any sort of common challenges in managing home workers, for example?
Yeah, I mean, I think the first thing is that you have to be much more structured.
Yeah,
When people are in the office every day, management by walking about can be quite effective. When they're not in the office, I think you do have to be very structured. So, for example, I think if you agree that a team will come into the office at least one day a week, it ought to be a three-line whip. I think if you're agreeing to have regular review meetings, you've really got to stick to them. I suppose in terms of common challenges, I think one is unmonitored informal home working, unintentionally morphing into a more formal arrangement. And I've seen that where people have said to people, well, you must be in the office 3, 4 days a week. And it turns out actually that since COVID, they've never been in the office more than a day a month or something. And the obvious question is, well, how did that?
yeah,
I think prioritizing multiple home working requests. I mean, at the end of the day, an organization has to fulfill its function. You've got to provide services and so on. And what do you do if you can't accommodate everybody's home working request? How do you prioritize? And I would suggest, for example, that you would probably need to take those equality factors into account, in the sense that if somebody wanted to work from home for an equality related reason, and someone else wanted to work from home because they just fancied working from home and didn't want to commute every day, well, if I couldn't accommodate both requests, I would pretty much certainly give priority to the one who had an equality related reason behind the request.
yeah,
I think reaching breaking point or maximum density, I mean, any organization is going to have operational and commercial minimum requirements. And I think planning ahead to anticipate, well, how many people do I really need in the office at any one time? Are there key parts of the week? Are there key parts of the month or the year, etc.? And trying to sort of schedule your home working around that is really important, because I do think very often when you get requests for home working, it tends to be quite a reactive thing. If
yeah,
someone comes in and says, I want to work from home, or I don't want to come back to the office, but actually planning ahead and saying, look, we struggle because the classic being Mondays and Fridays, the office is like a ghost town. Tuesday, Wednesday, Thursday is fine. Well, actually, one needs to plan ahead and say, look, we need, if you do, better coverage at the beginning and end of the week. So actually, let's look at the reasons why people might struggle to come in on a Monday and Friday. And actually, if some have better reasons for not being able to do that, we've got to have some sort of a rota that means we do have coverage. I think keeping the situation under review, I think by definition, atypical working and home working can't be set in stone. I might grant it to you now, but it doesn't mean it's granted forever. And
Yeah.
equally, of course, the other way round. Let's be honest. If you take our London office at Wakeman's, well, we've probably got 110 desks for about 280 people. Now, if all
Yeah.
280 suddenly said, you know what, we want to come back to the office 5 days a week, I'm not sure what we would do. And so I think keeping the situation under review really cuts both ways from both the employees and the employer's perspective. I think collegiality is important. I think one sees that particularly with the sort of generation. Again, let's take lawyers. Um, if you were a trainee or an apprentice during COVID and were working from home, and if you qualified post-COVID, but actually have always worked at home at least 3 or 4 days a week, you're simply not going to have established the sort of personal relationships and collegiality that you would if you look back pre-COVID, when people tended to be in the office rather more, seeing people going out for a drink after work. It's amazing, isn't it, also how often work opportunities become that because you overhear a conversation or you're microwaving your lunch and you have a chat with someone for 5 minutes. So I think that maintaining a sense of belonging and collegiality is really important. And I know it sounds a bit trite, but actually, I suspect that an awful lot of people who did in the law qualify post-COVID are rather more nomadic in their outlook career-wise because there isn't the same sense of belonging and engagement and loyalty, or call it what you will, when actually I'm working from home quite a lot. Because let's be honest, if I work from home 3 days a week, frankly, whether I'm working for one law firm or another, or one organization or another, doesn't have nearly as big an impact as if I'm actually going into a workplace 5 days a week, and so on and so forth. I think if you are permitting home working, then sensible employment contract terms are really important, building in sensible terms, flexibility, etc. And then I think, as I said, with remote management, I've already mentioned the importance of adopting a structured approach, but performance and sick absence management and discipline, etc. I think they're all the usual things in terms of discipline, making sure people appreciate that even though they may be working from home, the same standards of behavior are expected of them because, it is all part of the course of employment, a phrase that's sort of familiar to those dealing with discrimination. And I think in terms of performance, actually, one does have to measure carefully how people are performing because one wants to ensure that you don't get a drop off in performance. And I think, the hard data I talked about during COVID, well, it's become slightly more sort of grey and wishy-washy now with people doing a combination of home and work. But actually, how do you measure performance? It's an interesting question, isn't it, for a lot of organizations.
Yeah.
How do I, is the important thing the end result? Is the important thing how you go about achieving the end result? How measurable are people's outputs, and so on and so forth? And I think just sort of keeping all of that under review, because it's very much an evolving, living thing, all of this. I think we're still grappling with the whole sort of agile, atypical working piece. And we know that under the Employment Rights Bill, there will be enhanced rights to demand sort of flexibility and so on. But nonetheless, organizations, whatever they do, still have to function, still have to provide a service, and it must be a sensible balance between the commercial and operational needs of the organization and the needs of the individual.
Yeah, no, absolutely. There's some really, really interesting points there, and I think certainly those common challenges and the practical considerations for managing home workers can sometimes be overlooked. And I think it is really important to make sure, whether you're HR, whether you're an employer, that you've got some of those things in the back of your mind when you're thinking about whether it's flexible working requests or agile policies or whatever else it might be. So yeah, I think that's really helpful. Thank you, Mark.
No, that's a pleasure.
So for everybody listening, please keep an ear out for our other important employment law updates by subscribing to our podcast channel, The Employment Law Insights. But for now, if you do need any assistance with anything, whether it's HR or employment law related, then please feel free to contact me on rebecca.kearney@waitmans.com or Mark on mark.landon@waitmans.com. And huge thank you again, Mark, for providing us with that really helpful update.
That's a pleasure.
Thank you. And thank you, everybody, for listening.